arrest me on this tonight? Is there a way for me to make a call to organize the money that I owe?
On May 22, 2024, deputies responded to a Walgreens in Florida after Asset Protection discovered an employee theft scheme totaling $2,100. This case presents critical issues in employee fraud prosecution, constitutional protections during arrest, and the intersection of corporate policy with criminal law.
Hello. Hello.
Hello.
Hi, how are you?
Good. How are you?
Good, I'm Deputy Defraud.
My name is Deborah. I'm an asset protection manager with Walgreens.
Okay.
This is, what's your full name?
So,
What's your last name?
Okay.
So why don't you tell the officer what has been going on?
from like the whole,
You're employed here?
yes, sir.
How long you been working here?
A few months, sir.
A few months this year or
Yes, sir.
last year?
This year, sir.
Okay. And what's your title here?
Customer
service? Okay. You're not a manager or anything?
No, sir.
Okay. Alright, so what are we getting, what are we brought in the office for?
Are you asking me that, sir?
Now tell them what you did. I have a statement.
So, I
Hearing this,
rang up some gift cards to pay for my school and things like that. However, I did not pay for that.
Okay.
So,
Okay, so we're looking at a theft from the business.
and they said that there's a possibility that the company will let me pay that, which I'm willing to do. And they said that there's a possibility that if you're okay with that,
right now, is 2,100 grand enough?
I wouldn't be
Yeah.
prosecuted if I were to be able to pay it back today on the spot.
So
And then I would be terminated.
I couldn't negotiate anything like that. That's not really my job per se. As far as if you do this or that, charges may or may not be pressed.
At this point, he doesn't have $2,100 on him, so the company does want to pursue the prosecution.
But I'm able to.
Okay, but
That's
that's
actually-
not his now. Now we're past that point right now. So those are all the transactions
Okay.
that he rang up, and he did 2 today for a total of $400. Will you put it on a cash app?
Oh, yes, ma'am.
Is it still, you still have that $400 on the cash app? Okay. So
Okay.
the 2 that he did today
So there were 2 today,
for $400.
and the receipts are
All the
for going
receipts are
back.
right there, and he also has the video in there. Every single one is on video as well.
Okay,
Yeah, it's right here.
they're on right there.
That's up to 2 today.
You know we don't do thumb drives anymore, right?
What do you need?
We can do a computer link.
An Axon line?
Yeah. Are you guys able to do the Axon line?
They can't, but I can. But it.
Yeah, we try not to take thumb drives anymore. They want to write on that Axon link.
You know, I just got an Axon link from somebody.
22.
That's how they want it now. Just saying that it's their
Okay.
change. That.
Do you know how long
We can
that's
take that, but like I said, it won't get up because the problem is that doesn't get shared with the state.
Do I touch on
The state doesn't
Me.
have access
So-
to the.
There's nothing that
That's
you
why I
could
have
do
to go
to
Not
get
at
me
this
out
point.
of prosecution?
For what?
You're saying that there's nothing that you could do to.
There's nothing we can do about that at all.
Prosecution.
Are you a juvenile? How old are you?
I'm 18, sir.
18. Okay, so you wouldn't qualify for a juvenile first offender program.
So you're
That's
saying
probably
you
what
go to
you're
jail?
talking about. Yeah, you're looking at grand theft for the amount of about 2,100.
Even if I can pay it back, I'm still.
Yeah.
Like I said, that's not our fault.
Yeah, that's not our fault.
We don't play. That's Walgreens. We don't negotiate with that stuff.
So is there a
They're
way,
they've obviously contacted us for a reason.
They
is there a way
said
for
yes,
Walgreens
prosecute.
to take back?
I mean, listen, like I said, that's not up to me. That's up to Walgreens being a victim.
They looked it up, and you didn't have that much on your paycheck, so they said yes, prosecute and
No.
terminate.
But you're saying that they said that because I didn't have the money on it.
On
But if I was
on
able,
your paycheck, so that's why. So we can't do any more negotiating. Okay?
no, but I'm saying even if I was able to like get the money, like if I would
Yes.
ask my mother or my father, even if it's not on my paycheck necessarily, if I was to get the money and pay the money back, like legally, Is there a way that you could speak to them and see if they would be able to change their mind on the prosecution? Not necessarily the termination, right, but just the prosecution part. Even if I was able to pay the money like right now and not like
You couldn't leave the
drag it
store
out.
until it was
That's okay.
paid.
I understand that. I wouldn't want to leave
So what
the store.
are you saying that you'd possibly be able to make a phone call to settle
Yes,
this
yes,
debt
sir.
right now?
Yes, sir. That's what I'm trying to
Like I
say.
said, that's
That's
not.
up, that's up to
that's not up
Walgreens,
to
that's
me.
not us.
Is there a way that you could
I'm gonna talk to the
please
officers and the store
negotiate
manager outside. I mean, they've already
and
taken
see if
their
I could
time
just make a
on
call, not leave the store?
it. And they have places to be. I have places to be.
I understand.
So you
Well, just staying here with him. Real
Is
quick.
it
Yeah,
okay?
I'm gonna hang out here.
Is it okay if I make the call now?
Hold on a second.
Hold on. Let's stay here.
Sorry, ma'am. We're coming your way.
Thank you.
Not a problem.
I thought it really likely that he's gonna come up with $2,100 today.
Even if you did, no.
Even if that's what I'm saying. Even if you did, I can't tell him
No,
or
we
tell
know.
you guys, hey,
And
if you
it's-
pay this money,
This
then we
is-
won't pursue
It's
charges.
very disrespectful to
This
the
is a
store what he
Walgreens
did.
thing,
He said that
and
he
it's
said
up
he
to
didn't
what
know.
if
He said he didn't know what
Walgreens
was
wants to be a
wrong.
victim,
He
or
still
if
wanted
Walgreens just wants to terminate and trespass an employee.
He wanted to trespass. We want to also make a.
You want to prosecute.
We want to, hey, we're not going to tolerate this. We want the other employees to know.
He lives too close to here. I would rather prosecute. He's a liar. He's like, no, just prosecute.
And you know what? When I first started talking to him, he knew what asset protection was. He knew what loss
He's done
prevention
it
was.
before.
He's probably been terminated as from a
Maybe.
previous company. Because no, he knew what asset protection was. He knew what shrink was. He almost described my job at the beginning. So
Okay.
just tell him. He keeps repeating the same thing over and over. Just tell
The
him to
thing,
shut up.
the thing is that and I get it, but he's afraid that it's going to mess up his career going to school. But he should have thought about that long before he did this.
Right. And then, like I said, that's not my goal.
Kids from the
Exactly.
time they're in kindergarten know you don't steal. You know what I mean? From the time that they can walk, you don't steal.
Right.
Well, I didn't know that it was wrong.
So listen, regardless, knew, didn't know, can get the money, can't get the money. I just need to know the
Prosecute.
decision on whether we're prosecuting criminally or if we're documenting and trespassing from the store completely. That's something that you guys should probably have a discussion right now and then let me know. Okay?
We're going to prosecute criminally.
Okay.
Have them arrested.
Okay.
I ran him. I don't know if you heard me.
What's that?
I ran him. I didn't know if you heard me.
No, I didn't.
Situation.
Okay. So here's the situation. I talked to Walgreens, obviously representatives. They want to pursue criminal charges. Okay. I know you agreed to pay them back or whatever. I guess it's beyond the point to where they're willing to agree to that. So we're gonna have to go this route. So any payback would be through a restitution through the courts. Have you ever been arrested before?
Yes, sir.
Okay, for what?
It was a drive
A what?
drive. It was
Driving?
street racing, but I wasn't, so it got dismissed.
Okay. Alright, here's what I'm gonna do. Okay. Right now you're not free to leave. We're doing a criminal investigation. Let me see if you'd like to provide a statement. Okay, as far as what occurred here.
So I'm gonna be arrested right now.
I'm not done. I have to look at one more thing, but it's a very good chance.
Also, there's still a possibility.
Let me read this to you, okay?
Okay.
Hold on, 03 Harold.
I'm required to warn you before you make any statement that you got the following constitutional rights. Okay. You have the right to remain silent and not answer any questions. Any statement you make must be freely and voluntarily given. You have the right to the presence and representation of a lawyer of your choice before you make any statement and during any questioning. If you cannot afford a lawyer, you're entitled to the presence and representation of a court-appointed lawyer before you make any statement and during any questioning. If at any time during the interview you do not wish to answer any questions, you're privileged to remain silent. I can make no threats or promises to induce you to make a statement. It must be done on your own free will. Any statement can be and will be used against you in a court of law. Do you understand those rights as I have read them to you?
Yes, sir.
Okay. With those in mind, are you choosing to speak with me about the incident?
Is that a good idea?
I can't make a recommendation. I just, basically, are you willing to speak with me today about what's been going on?
That's okay.
So, talking to them, they said that you've basically been engaged in an ongoing course of action, loading gift cards fraudulently. Your drawer's been coming up short, and you've been pocketing the money. So, the gift cards, okay. They said that there were some transactions today that were done, I guess, on your phone.
Yes, sir.
I don't know how that works. You'll have to explain it to me. But so right now, the allegations right now are grand theft. Okay, from Walgreens. How long have you been employed here?
A few months.
A few months, just this year.
Yes, sir.
Okay. Do you work the registers?
Yes, sir.
Okay. Now, from what I've described to you that you've been accused of, which I saw your statement as well. How does it work with loading the gift cards?
You just type it in. And then
Okay.
Just
So describe to me what you were doing with the gift
like
cards.
the action of
Yeah.
it. Just scan it, and then just type in the amount.
Is it like a sale? You scan it like a sale?
Yeah.
Okay.
Yeah, it'll be
And
like
then
so.
and then you load it. You
Yeah,
load the
you
gift
just
card
type the
through the
money in.
register.
You just type the amount, and then you just like proceed with the transaction.
Okay. And then you complete the transaction.
Right.
And then you just
But
pocket
there's
it.
no like touching of like any like money. Or
No, not physical money because
Right,
it's
right.
loaded up on the gift card.
Right.
And then you would keep the gift card.
Right.
Okay, without paying the money into the register.
Right.
Okay. You know that's wrong, right?
Yes, sir.
You know that's theft from a business who's already paying you a paycheck, who's trusting you to work for the store on their behalf, right? So that's what we're dealing with. They're telling me that this has been an ongoing course of action since the beginning of April. Do you know about how many times you've loaded gift cards?
Not off the top of my head, sir.
Just because it's so many?
Not necessarily. It's just like I just don't really like. I wasn't really thinking about it too much.
Okay. Let me ask you this real quick.
Right.
This is a statement you did with
Yes, sir. With Miss Deborah.
Miss Deborah,
Yes,
as
sir.
far as regarding the actions that happened here. Okay. You wrote this?
Yes, sir.
Okay. Do you swear that what you wrote in here was true?
Yes, sir.
Okay.
Did she even make the call?
Call the who?
Call who?
She said she was gonna speak to.
I don't know because I wasn't with her the whole time,
Right.
but they've determined that they are going to pursue charges.
And there's still no way that I could potentially try to,
No, not right now.
even if I asked again to maybe.
Yeah. Yeah, trust me, I asked them, I told them I need a clear answer, basically before I proceed, any further, and unfortunately, this is the decision
Can I just
that
make
they
one
have
more
made.
attempt?
One more time for what?
For me to. Did she leave?
No, they're still here. But I understand what you're saying,
Right.
but we are beyond that. They are beyond that. Okay? Asking again isn't going to do anything because we've already had that conversation and the decision has already been made. Okay? That's why, hypothetically, had this just been a one-time deal, and then you came back, oh my God, I'm so sorry, this is what I did, here's the money back, no harm, no foul, maybe this could have been a different scenario, and you may have just been terminated. But like I said, there are numerous transactions totaling up to $2,100. So it basically just shows he's still doing it, still doing it, still doing it. So why is he still doing it? You know what I mean? So
Okay, so is there a way for me to make a call to organize the money that I owe?
So here's the thing. We're not going to make phone calls to make payment. Okay.
Excuse me, sorry? Can you repeat that? I'm sorry.
We're not going to make phone calls to make a payment to Walgreens for the amount. Okay. This will be restitution.
What's that?
Basically decided by the courts whether you have to reimburse the money or not, and that's when that would be paid back. Okay. In the meantime, I wouldn't contact them. I wouldn't.
Most likely they're gonna trespass you as well.
Yeah, most
so
likely. Yeah. So most likely you're going to be trespassed. Normally, how this goes is if they owe you a paycheck, it'll be sent to you in the mail.
Well, I don't even know if that, because the way you made it sound like they're probably gonna take the paycheck, so.
I don't know.
It's part of their financial restitution, sounds like they're gonna take a check.
Okay. Oh, that's what she said. There's not enough money
Yeah.
in the paycheck.
Yes.
Gotcha.
I'm thinking they're gonna take his paycheck for restitution, some of the restitution, is what I think they're gonna do.
So,
I don't know for sure, but
Yeah.
go ahead.
going to jail.
Yeah.
Like jail, or like
Yeah.
holding.
Do you have anything in your pockets?
Like illegal?
No, like anything.
Yeah, I have my phones.
Okay. Stand up. Do me a favor. Just put your
Is
stuff.
there a way you could arrest me on the side?
No, but we can try to conceal you.
Is that-
Okay. And try to keep you away from customers. I'm parked on the side of the building. I'm not parked at the front. Okay. We're not going to make
We're not gonna make
a big
of
scene
this,
about
no.
this.
Is there a way I can call my mom?
Well, we can make some phone calls after this.
Yeah. we can
Okay.
make some
I don't
phone
know
calls.
the numbers off the top of my head though.
So that's fine. We'll
which
get
will
it.
allow me
We'll
to
get it from your.
access.
We'll get it from your phone. Okay, but I still got to write the report. Okay, we're gonna go back to the office, and then we'll wheel and deal on the phone if you need to notify your mother. Okay.
It's just like a sentence type of thing, like a jail sentence.
No, this is just for the initial charge. Okay.
You know what I'm saying? Like when you arrest me, like I'm going.
You're going to jail. You're being charged with a crime. Okay. It's a non-violent crime. It's not domestic. If you talk to your mom later, she can bail you out. You can be out today, or you could
Is
be
it
out
possible
tomorrow.
I can be out today?
Yes. Yes.
Like for good.
Well, until your
court date.
you'll have to go to your court date,
Yes.
So she could bail me out, and then I'll.
but you'll be obligated to go to your court date.
Processing, I'll be straight up with you. Processing is gonna take 2 or 3 hours.
Yeah, I know. When I got arrested the first time, they put me in a holding cell,
You're gonna go the same thing.
Yeah.
and then like I was there for like a lot of hours, and then they allowed her to bail me out.
Yes.
Well, like I said,
We got a lawyer.
you got to realize something. Once we get to the jail, that's beyond our control. That's not our side of the business. So however long they keep you in that intake and things like that, that's on them. We can't tell you how long you're going to sit there for. There's no guarantees on that.
But there's a guarantee that I can get out today, is what you're saying. Or you can't guarantee that either.
Well, with a nonviolent crime, there should be able to put a bond on you.
What's a bond on a
I
felony?
think it's
3.
2,000.
I thought it was 3,000.
Is it 3? I thought it was 2.
So listen, it's 2,000 or 3,000 for the bond. You get it if they get a bondsman. You only have to pay 10%. That's $200 or $300 with a promissory that you're going to go to court and you're not going to run.
Yeah, some type of collateral.
Yeah.
Okay.
She may have to sign her car or something. I don't know.
Right.
Or pay the money up front and then they'll reimburse her. That's up between the bondsman and it's whoever posts your bond.
So anybody can pay my bond?
Anybody
Yeah.
can pay. Anybody
But do
can
they
post
have to be here to pay the bond?
No, they got to pay the jail.
They gotta pay the jail.
No, I'm saying not here, but I'm saying like they have to go to the jail
Yes.
to pay the.
Yes.
Yeah.
In order for your release, they
So
got
there's
to
no way they could like
Can they do it over the phone?
I
do
don't
it
know if
over
they do
the
it on the
phone
phone.
I don't know if they do it on the phone.
No, because it's cash. They got to pay cash.
oh they have to pay cash.
The bondsman may go there
Yeah.
and pay it.
The bondsman might be able to wire, but your family has to pay cash.
And it has to be my family that does.
Well, anybody that's bailing you out
Yeah,
has to pay
whoever's
cash.
bail, it could be a friend.
So if
could be
I
a
call
friend.
a friend to bail me out, is there a way I could do this without
No.
my parents?
Yeah.
Well, yeah, without
Yes.
your parents.
Yes,
you make a
you're
phone call.
18.
That's what I'm saying. Like, is there a way
Yeah.
that I could do this without my parents?
Yes.
Yeah, you can fucking call.
Potentially without them even knowing.
Well, that's
Yes.
what I'm saying. Yeah, you're an adult.
For real.
Yeah.
Yes.
So you can call your friends. I mean, the worst case.
Can I write their numbers down?
You can,
If
not
when you give me the
not
opportunity,
here.
You give me the opportunity.
Yes.
Yes. Yes. But yes, you can contact friends, and friends can come. It doesn't matter who comes and pays cash.
The only thing is, I don't have any friends out here. They all live in like different states, like New York and Georgia.
Okay, well,
So that's why I asked you.
Well,
if
then
you
maybe
were
one
able
of
to-
them will have to call a bondsman
Yeah.
on your behalf.
Right.
They can explain the charge and where
hopefully
you're
you have a
at,
friend that wants to put up collateral for you.
Yeah.
That's the thing.
and then they can pay the bondsman, and then the bondsman
Yes.
can pay
Yeah,
the
because the
jail.
bondsman will come take care and pay the cash. They can get a hold of a bondsman.
Okay.
Otherwise, will they do OR maybe? They may release you in the morning, or they may release you on your own recognizance, which pays.
Well, what happened when I got arrested the first time? I think it was OR. But my parents, yeah, it was OR.
You weren't 18, were you?
I was.
Okay,
He had
It was-
to be
it was
18.
OR.
He had to be 18
It was at like 4 o'clock in the morning.
because it's traffic.
could be.
Sorry.
It could be
it-
4
like,
o'clock.
Okay,
in the
so
morning.
we don't deal with that process. They
Yeah.
have their different time slots. They have all that stuff over there. We don't know when they release. We don't know that stuff.
I don't
All
know
we
the
know is
line,
court
shift
dates.
change, when the paperwork goes through, when the payment goes through, when notifications are made.
8
that's all
a.m.
at the
court.
jail.
Every morning, 8 a.m. is court out west. So I can tell you that for a fact. That's about the only thing I know in that business is court at 8 a.m. every morning, except for Sundays.
Okay.
They're on call for Sundays.
So, listen, I know you've been very respectful. We're trying to answer your questions.
I'm sorry for asking.
No, you're fine.
We're not, listen, we're not holding this against you. This is just something you and Walgreens are going to have to deal with.
Yeah.
Okay. But for the time being, I need you to take your jewelry off, empty your,
Can I
put your
keep
stuff.
it?
You're going to keep your
We're
stuff.
gonna keep all
You
your
just
stuff.
can't wear it.
You can't wear it.
Right.
I have to put it into a separate property bag.
Okay.
I don't know. I don't know if they want that lanyard that you have. So I just leave that. I mean,
You don't just leave it here?
The lanyard, yeah,
I would
we'll
just
leave here.
the
It's probably
lanyard.
property of Walgreens.
Right. Okay.
Put that on the desk behind you.
Okay. And there's no way you could arrest me outside?
No.
No, trust me, we'll just
I
walk
just
out
don't
with
want
you.
people to see me. That's the only
I
I
understand.
can get up?
Yeah,
Yeah,
yeah.
You have to empty out all your pockets.
You want to just put it right here?
Yep,
Yeah,
well,
right
right
there.
there. Right on that piece of paper. Take your earrings out.
I'd
Nose
say my
ring.
ears off.
Huh?
Well, if you don't take it out, the jail's
I
gonna
have to
take
take
it
this
out.
off?
Yeah.
Yes.
I know. It's not going to close up in one day.
And my,
Well, then you may have to get it re-pierced.
is there like
A mirror?
it's
No.
not a mirror, like somewhere I could put it? Like,
It's gonna go in a plastic
I don't
bag.
wanna
We're
lose
gonna put it in
We're
the
going to put it in a bag. Okay. Nothing else in your pockets.
Oh, no. I'm
did
sorry.
Somebody text you?
Yeah.
Who's that? Okay. Turn around. Put your hands on your back.
You please not feel like really tight though. Last time, obviously.
The employee was ultimately arrested and charged with felony grand theft and scheme to defraud. He received 12 months of probation, walking away with a second chance, but not without consequences. Was justice served, or did he get off easy?
The suspect made a voluntary admission before arrest, stating he activated gift cards for personal use. This raises immediate Fifth Amendment concerns. Under Miranda versus Arizona, police must advise suspects of rights only during custodial interrogation. Here, the suspect was not in custody when he confessed. Because he was free to leave and spoke voluntarily, no Miranda warning was required. His admission is fully admissible in court. This illustrates a critical legal principle. The Fifth Amendment right against self-incrimination exists at all times, but Miranda protections apply only in custody. The suspect's better strategy would have been invoking his right to remain silent and requesting counsel immediately. The theft amount of $2,100 triggers felony grand theft classification. Under Florida Statute 812.014, theft exceeding $750 constitutes grand theft third degree. This felony carries penalties up to 5 years imprisonment and $5,000 in fines. The suspect faces serious lifelong consequences beyond incarceration. Felony convictions impact employment, professional licensing, educational financial aid, and in some states, voting rights until sentence completion. The suspect repeatedly asked whether paying restitution could eliminate charges. This reflects a fundamental misunderstanding of criminal prosecution. Theft is both a crime against the victim and a crime against public order. Once law enforcement is involved with probable cause, prosecution decisions rest with the state. Restitution can be a sentencing condition or plea negotiation factor, but it does not erase criminal liability or prevent prosecution. The deputy's arrest was constitutionally sound. Probable cause existed based on documented video evidence, transaction receipts, digital payment trails, and the suspect's admission. Under Illinois v. Gates, probable cause requires facts sufficient for a reasonable person to believe a crime was committed. That standard was clearly met here. The deputy's use of force merits analysis under Graham v. Connor. This 1989 Supreme Court case established the objective reasonableness standard. Force must be judged from the perspective of a reasonable officer at the scene, not with 20/20 hindsight. Handcuffing alone is minimal control technique, not elevated force. Given the nonviolent felony, cooperative suspect, and controlled environment, handcuffing was entirely appropriate and proportional. The deputy demonstrated Fourth Amendment compliance by not searching the suspect's phone. Under Riley v. California, cell phone searches require warrants. Even during lawful arrest, digital devices receive heightened constitutional protection due to the vast personal information they contain. Walgreens' investigation exemplifies proper corporate evidence gathering. Transaction logs qualify as business records under Federal Rules of Evidence 8036. These records are admissible exceptions to hearsay because they're created in the regular course of business with established reliability. The video surveillance, Cash App digital trail, and paycheck analysis created an overwhelming prosecution case with multiple corroborating evidence streams. The suspect's question about juvenile programs raises age jurisdiction issues. At 18, he's legally an adult in all 50 states for criminal prosecution. Roper v. Simmons established that 18-year-olds are treated as adults for sentencing purposes, eliminating access to juvenile diversion programs. Deputy Dell receives a grade of A-. His constitutional compliance was flawless. Lawful arrest with probable cause, proper Miranda understanding, Fourth Amendment respect, and appropriate force under Graham v. Connor. He maintained professional demeanor throughout and provided accurate legal information. The only weakness was efficiency in managing repetitive questions about restitution. A more directive communication style would have concluded the encounter 7 to 8 minutes sooner without sacrificing professionalism. The suspect received C+. He demonstrated full cooperation with no physical resistance, which likely influenced his eventual sentencing to probation rather than incarceration. However, his voluntary confession without counsel was a critical error. He built the prosecution's case by confirming theft, method, and motive without legal obligation to speak. His repeated focus on restitution showed legal naivety about how criminal prosecution functions. Most significantly, the original decision to commit systematic employee theft was obviously criminal. Walgreens Asset Protection receives B+. The investigation was thorough with excellent documentation, video evidence, transaction receipts, digital payment trails, and paycheck cross-reference analysis. Their decision to prosecute rather than accept restitution was legally sound and sends clear deterrence messages. The minor weakness was communication efficiency. A clearer, earlier statement that restitution was already considered and rejected would have eliminated circular conversations. Key lessons from this case. First, never speak to law enforcement without counsel, even in non-custodial settings. The Fifth Amendment protects against self-incrimination at all times. Second, understand that restitution does not eliminate criminal liability. Theft is prosecuted by the state, not negotiated privately with victims. Third, employee theft creates overwhelming evidence through transaction logs, video surveillance, and digital payment trails. These cases have extremely high conviction rates. Fourth, cooperation with law enforcement may influence sentencing, but does not erase charges. Strategic legal decisions require attorney guidance from the outset. Finally, felony convictions carry lasting consequences beyond incarceration. Employment, education, licensing, and civil rights can all be permanently affected. The case concluded with felony charges of grand theft third degree and scheme to defraud. The suspect received 12 months probation with $2,100 restitution. This represents balanced rehabilitative sentencing for a first-time nonviolent offender, but the felony conviction remains on record with lifelong consequences. This case demonstrates constitutional policing in controlled arrest scenarios and illustrates how small decisions escalate into felony charges with life-altering impact. What are your thoughts on the 12-month probation outcome? Share your perspective in the comments below, and subscribe for more legal analysis of police interactions.